Hey everyone, this is Chiteshri from the Human Rights Course team, and I am live from New Delhi with our very special guest, Dr. Colin Gonsalves. We have Professor Joshua Castellino and Professor Sarah Bradshaw, who are live in London. It is 1 p.m. out there and 8:80 p.m. in India, and we're all set. Very final, like the Human Rights Course team. A minute to check if we are on the live broadcast from my colleagues. So just give me 1 minute. Sobia, is every word being caught? All right. On the call or on this hangout with us, mindful of the fact that there's a 10-second delay. Speak very slowly so this. So I'd like to start by introducing Dr. Colin Gonsalves is the 2007 of the Right to Livelihood, the Right, and it is also known as the Nobel Prize. He is a senior advocate court of India and somebody who is well known for a lot of positive change in this country due to litigations that he has filed. He's also responsible for the right to food as part of the extended F21. With many questions that we have, and also Dr. Gonsalves is with here. He and friends for a while. Connection is gone?
It's coming slowly.
Yeah.
Speak a little slowly.
Dr. Gonsalves is here with us. We've been friends for a while, so I'm gonna Joshua to say a few words with any questions that we have.
Yes, Chiteshri and Colin, thank you very much for accepting this invitation to join us. Your work is sterling in our field of human rights, and I think it's inspired so many advocates all around the world. And I really wanted our students who've been studying with us questions on human rights and gender for the last few weeks. I wanted to give them a chance to hear you speak. So we would like to hear quite a lot from you, and maybe just a few words from time to time from Sarah and me. The Right Livelihood Award, of course, has recognized the sterling work that you've done in holding government to account. And I think that work stands out as a beacon of hope at really what are quite dark times. My question to you, Colin, just in terms of what words of advice you would have for people who are committed to sustainable development goals and committed to understanding how you can use the sustainable development framework to emphasizing inclusiveness, to wiping out the barriers that exist. Could you say something to us on what your philosophy has always been and that's motivated you to do this kind of human rights work that you've been doing over the last 3 decades?
As you know, the Indian Constitution gives us a very virile Supreme Court. Sort of revolutionary changes in the 1980s and 1990s. The court, for people who are very poor, for the bus ticket to reach a lawyer, and basically made access to 150 people who are below a poverty line. So when we started using the Constitution, so to speak, to fight for the rights of people, found that our court from the Western system to a very novel system where we jettisoned the extra emphasis on private rights and we moved into collective action. Thousands of people in the right to food came to millions of people. So a single case, a single lawyer, which is an NGO, and a case done on behalf of millions and millions of people. So the Constitution is a very, and any country constitution which life. In India's Article 21, but every constitution would have. So many countries in Africa, almost all countries of Africa, countries in South America, large parts of Asia, institutions which are very, the language may be slightly different, this may be different, very entrenched, and it's very possible constitution and constitutional law remedies in the Supreme Constitutional Courts, by whatever name called, remedy to take collective cases for the human rights to these bodies and change the country, change the situation regarding human rights. Saying this part of the program, I ended by saying to the West, jurisprudence and West for answers, collective answers. It would be better to look at the constitutions of our own countries and look at the remedies and potential and use those to achieve massive victories.
Yeah, you know, Colin, we have throughout this, throughout the MOOC, Sarah and I have had this standard banter between us and disagreement between us about the role that lawyers play. And, you know, Sarah's argument, Sarah, I'm paraphrasing, so you can correct me, I'm sure you will. Sarah's argument essentially is that law itself is a patriarchal system. It's not just, I agree with Sarah on that, I have to say. But in a sense, when we start using law to achieve social change, we might achieve some social change there, but somehow we reify the system and we justify the system existing. You want to try and put that better than I did?
Yeah, I think the argument is more around the law as a system is, as Joshua says, is a patriarchal structure and part of institutionalized patriarchal structures. It's one of the main ones. And to what extent then can we actually bring change from within a patriarchal structure? Are we not just reinforcing that structure through actually engaging with it? I think that's one of some of the issues around, or how can we actually then subvert these structures in essence, if we turn it on its head? How can we actually use them? How can we subvert them, given that they are pillars of established society and keeping society as it is? You've obviously very successfully done this, so it'd be interesting to hear your tips on how we can go about subverting these patriarchal and neoliberal structures.
Well, Sarah, I would agree with that. It's a very patriarchal. I suppose laws right across the world are very patriarchal based. And in our country, we also say very caste based, so that the low caste sections of society are excluded. Able persons, very positive persons, class persons, very anti-tribals, and so on. So the law is a very of oppression. Also engines of oppression. Constitutional, you will always find and gray areas for insurgent law. Or professional enough and you work hard enough and you mix your law with social movements, human rights. You mix your law with people, living among people, law and society change. Sometimes you find very respond to human rights lawyers and act positively. Great moments, some great moments actually takes place. All young people, no matter how bad your system may be, what your judges may be, no matter that you have only male judges, Supreme Court, all male judges and no female judges at all, and all that kind of stuff. Constitution gives you a possibility, a chance, and to use the Constitution as a sword against the oppression. That well, have some tremendous thoughts. And I would say, rather than look at the dark side of the system and the law side, as much as you can, don't abandon this arena warfare, or or Dalit warfare, whatever. It is an arena of war. Not retreat. We must still fight.
Colin, Sarah, do you want to react to that?
Yeah, that's really. I like the point you made about the need for law and lawyers to link with social movements, and that groundswell I think is really important. But I'm always interested by which way then it's best to see that going, whether social movements approach someone within the law to support them, or whether it can come from the law going to social movements. And my feeling is very much it needs that movement at the base and then seeking that legal support. But maybe it could be the other way around. I've never really thought about it working, for example, the other way around, coming from those working within the law profession and linking with or mobilizing social mobilization. It's quite interesting to think of the other way around.
Colin, I'm wondering whether that strand, whether you could maybe develop that strand a little bit by telling us the Human Rights Law Network story, because I remember the early 1990s, and it's hard, and I know lots of people are studying your model and looking at the impact it's had, and I think it's hard to really categorize HRLN as an NGO, because you could just as well categorize it as a movement. And it would just be interesting, I think, in terms of Sarah's dilemma there, and especially in terms of lessons in other places. Tell us a little bit about the HRLN story, where it started, how it evolved, and whether you see it more as a movement than an NGO today.
Okay, Joshua. Well, you know how we started. I was a trade union activist, and my colleagues with me were educated women's activists, slum dweller activists, and so on. Started with activism, moved to the law. Have always been in activism. So the law struggles of people. Here at mixture of, it's like a flip between social movements and lawyers. I would say, first of all, that thing apart, we lawyers are nothing apart from what we are, friends in the social movements. And every victory, every single thing that we owe it to the people who taught us how to see the world through us people, and how to have a gut reaction so that you don't really have to read and what stand you're going to take in the High Court or the Supreme Court. That mixture, because at times, once the lawyers imbibe certain values, movement teaches you that the ordinary people, the working class people teach you, to go a little step further sometimes and advise and guide on legal strategies. We'll say, all right, we listen to the lawyer because he's listened to us and he's respected us and he's learned from us. So talking sense when he says that we're going to do. So in the Human Rights Law Network, we send all our areas where we fight against evictions and mining companies and so on, where they fight against evictions. And we are constantly in the thick of social struggles, to go onto the streets and demonstrate and get arrested if it's not to worry about spending a night in jail. So it's been an admixture. It's been a lovely combination, work and struggle.
And Colin, could you tell us a little bit about the gender cases that you're doing? I think there's a case in particular at the moment in the Indian Supreme Court, and I don't know if you're allowed to speak about it, which really maybe shows as well the length of journey that India has to go on gender equality.
The rape case, right?
Yes, yes, I am.
You know, yes. Well, India is pretty far behind relating to marital rape is concerned. Law laid down by Lord Hale, 18th century. Once married, it means to sex with her husband anytime he wants it, whether she likes it or not. Stupid English carried over to all the colonies, and we have that on our statute book in India today. The exception to rape, which is marital rape. That is to say, if you're married and you forcibly have sex with your wife, and that case has come before the Delhi High Court, that that case exemption will disappear forever. We follow, of course, the decision of the House of Lords about a year and a half ago. Nepal leading us with a 1994 judgment saying that it's unconstitutional to exempt married men from the rape charge. And of course, right across the world, change has taken place. But India is still very, very, and Sarah, you mentioned patriarchy. You can imagine saying in court that marital rape doesn't happen in the East. It doesn't happen in India. Spiritual and so on. It only happens in the West. And Mr. Gonsalves ought not to bring in all these Western concepts into Indian courts. And so we showed them a study done by the UN in several states of India, where they asked men, do you have sex with your wife even though she says no? Said of Indian men was so proud to announce that yes, we do have, whether she likes it or not. And so I think this code is going to have end results. I'm definite we are going to succeed. And this awful, awful area of violence against women, I think will come to an end as far as the law is concerned, at least.
Joshua, before I actually have a question that has come in live from Munir, who's asking that how much of the execution just when the majority of people in administration are from the upper caste or class majorities. I think this is a question for Colin himself, so I will turn it over to Colin. But thank you so much, Munir, for that question.
Well, Munir, it's an uphill battle. The majority of the population is really, and it's very hard really to break through. But the Constitution is there. A Constitution for the minority and the people who are generally voiceless. One doesn't really, I mean, one needs a Constitution in any case for everybody. Need it the most. And the low caste, or the Dalits as we have in India, or minorities, Muslims, whatever, need the constitutions because constitutions protect the human rights of all people. Apart from this English, the old of party and parliament supremacy, and you imbibe what is called the supremacy of the Constitution. It's the Constitution which is supreme. And once the Constitution is supreme, the majority, the law of the land and human rights and so on, and the application of the Constitution, the articles that protect the rights of minorities, that is supreme. So one has to work in the system and develop the system so that the constitution is used by minorities, though they may be in small numbers, and yet they can win battles against the majority of the population. And there was an in India, well, it's criminal to, to have a sex nature is criminal. People protest. Very few people protest, saying that it be criminalized. It's constitutionally protected. Protest. The judges first said, "Well, it's very few matter. It's not an important issue in India." And now a 5-judge bench of our Supreme Court is going to sit soon and commence hearing, and they're going to say it doesn't matter. There's a million people or 10 people. Constitutional law and constitutional protections of the number of people involved. And that's why constitutions are very important in the property rights.
Apologies. Joshua, I could follow. And our theory that we have in the do we understand is something that is accessible to people who are, or do we say that the language and the terminologies that are used in self and accessible? Do you find who come from minority groups? Irrespectively, when we're talking about the international, it may not necessarily be caste specific, but there are various other candidates who may not have access to the various provisions available.
Yeah, I mean, Chiteshi, that is a very good question, and I think it does follow on from Munir's question and the way in which you have answered it, Colin, which I fully agree with. In a sense, you do have the problem that the language has been written. The language of law is an elite language written by the elite, and that elite essentially tries to negotiate the rights of all in and among an elite setting. Add to the elitism, patriarchy. So you have elite patriarchs who've written a text in a language that elite patriarchs can understand, and then elite patriarchs are the ones who then can articulate for the rights of everybody in that narrow setting. And I think this is why, if you think about one of the first sessions in the MOOC, I talk about, imagining that Athenian democracy and imagining who are the people who are doing that writing. And all of the people in that picture would be men, and they would all be landowners, and they would all be elite. I think where the project of law has been subverted already in the 1940s, and which has been now turned into a movement by the activities of people like Colin, where it has been subverted is to take that element of justice, that promise of justice made by the elites among themselves, and translate that promise into a social movement. I think that's where the human rights story really kicks off in 1948. And then you have people like Colin who have been able to break that language down, break those barriers down, break into those settings, speak that language, and then carry other people in. I think that's where that change has come. And I think this is the change, and this is the part of the law that is the most exciting. I don't mean the most exciting, human rights is the most exciting, it's the most exciting bar none. It is the absolutely emancipatory heart of all legal systems now. And it has made a change. And it started off with women coming into the equation. And then it spread to much wider groups coming into the equation. So it's not so normal now to have people who are victims not represented in their legal counsel. You do have legal counsel now. And I think, Colin, your movement particularly has given us so many unbelievably good women and Dalit lawyers and Muslim lawyers and lawyers in the various states that are obvious minorities. Now you've got transgender lawyers. And I think so the movement itself has changed. But of course, remember, they're still speaking that elite language. They're still speaking that elite language to the elite judges. But what they are doing is they're forcing the agenda. And that's where we've got to at this stage. And it's imperfect. You could say, yes, let's rip it up and start new and let's make it differently. but it is what we have at the moment. And I think so Munir's question is a good one, but I think Colin's answer is a very good one, in that you use the tools that are available, you understand strategy, and you basically understand that when you talk about a bar in law, being called to the bar, that bar is not a drinking bar. I mean, that already would be exclusive. It's actually a bar as in we're excluding you bar. Yeah, you cannot pass this bar unless you look like us, speak like us, dress like us. And all of these barriers have been put in the way. The word bar, the heart of the word bar, comes from barrier. And law, one of the things that defines law is barrier. And I think one of the things that we've learned in human rights practice globally is how you transfer and how you transcend those barriers. And I think it's the skill set, the passion, the dedication, and people from within that social movement who've understood that, fine, okay, so you want us to speak some Latin? Okay, here we go, we can do Latin. Oh, you've got some other arguments from Plato. So that's not something you throw at a Greek wedding? Fine, I'll go find out what it is. Fine, I'll give you that. So it's about understanding how you can use, with intelligence and strategy and passion and drive, to take something like that and to effectively decolonize it. And I think that's what has happened with human rights and law. But
I was just going to come back to something that Colin said when he was talking about the men who proudly said, yes, I force my wife to have sex with me even when she doesn't want to. And I might say that's not just Indian men who proudly say that. I've done research in Latin America, and the men say that also. And the women say that that is their duty to accept that. So, and I think that highlights that it's one thing being able to use the language and turn the language back on the elite, but it's also another thing being able to take that elite language and translate it down to those men who think it's okay to have sex with their wives even if she doesn't want to, because the law is a law that they will know about, but that doesn't change what they think. And therefore you still have the other translation process that's needed to translate it back through, not just what the law means for those people, but why that this should be seen as a problem. So I think you've got two ways that you've got to translate that through. And I think, Colin, it sounds like you're doing a great job of actually using the language of the elite to challenge the elite, but also taking that language and thinking about how to put that in other terminology that then we can have the discussions in households, in communities at that level, which I think is the other major step that needs to be gone through.
And Colin, would you, I mean, in a sense, I know that you're very modest in describing HRLN, but I guess in the world of HRLN, that kind of dynamic that Sarah is talking about is offset by the fact that you have almost as many social workers working in your movement as you have lawyers. So in a sense, you do that translation work as you go along.
Yes, and that's been our policy, right? That although we are known as a law office, we are actually a 50-50 combination of lawyers and social activists. And the insights into a case, very often the understanding of basic principles comes not from the lawyers, but from the social activists. And it is that combination of social activism and law that has given us a certain degree of success in winning cases. Lawyers, as a breed, as a class of people, very full of themselves and very, very, very this section and that section and this article and that judgment and so on, to really communicate with people. The basic and the wonderful principles of law, justice, and human rights, they're totally incompetent. As well, and it might be some of our lawyers in our human rights law network also have some pretty obstinate to try and change. So we do that. We bring our lawyers through social activists who work in, and through the movements that, really keep our lawyers carefully, see how they speak, see what stands they take, see if they're becoming condescending with people. So the real control our lawyers are basically the social combination is, I think, a winning combination.
I think that's great. When I pointed at Joshua there, of course, Joshua isn't one of those lawyers that is like that. But I mean, obviously, the lawyers that I've come across, they have been very much like that. And they can make you feel very stupid and very small. And that's great that you control your lawyers and watch what they're saying and make sure they're not talking in that way. I think that's really so important, so incredibly important. Such a really great skill for people who work in the law to have, is to be able to talk to people and not talk down to them, because that's fundamental for people to have a confidence that they will actually see through their cases and actually do support that.
Yeah. Sarah, we are very strict. We ask them to go to participate in meetings, sometimes live there, time, and not to tell them about what they've learned in college, because it's thoroughly useless, about sections of statutes and things like that, because that's not the way you communicate the magnificent spirit of law. And listen for long periods of time. And at the end of listening, make suggestions tentatively and politely. And we really that our lawyers are people all the time. And be respectful, speak English, and are often very timid in putting their points of view forward, and often think that they don't have human rights. So many women in our country don't believe they have a right to, bodily privacy, bodily dignity. If you go to a village and ask women, does your husband have a right to beat you if you didn't make him food properly at night? And I would think half the audience would, maybe more, would put their hands up. With a wonderful population, a beautiful and very sensitive, very spiritual class of people who are very, very poor, to learn from them and respect their lives nicely. And it's not easy to do that a lawyer does that before they start talking about, their law practice and their understanding of law. Very hard to unlearn what you've learned and to start your learning from scratch. And that's what we tell lawyers after you get your law degree.
Joshua, for you, do you mind if I bring that in out here?
Please. Question for you?
So this is a question for Sadhya, from Sadhya, that in Africa currently there's a lot of international being made of actually tapping untapped resources that are available. A number of violations happening by large investor corporations, by large companies, and they are all towards obtaining natural resources for a certain group of people and a certain group of countries to obtain certain natural resources. A broader question is, do our human rights networks and resources, the various mechanisms in place, can they actually challenge this process? Do we have remedies to actually stop this mass volume of development?
Thank you for that question, Sadhya. Thank you for the question, and thank you for bringing it up, Chiteshri. I mean, it's the question, do we have enough remedies? The answer is yes, we have enough remedies. We understand how corporations can be fined. We understand how people who've lost their land can be compensated. We understand principles on restitution. We understand a process through which you can create licenses. We understand how you can guarantee accountability. Yes, do we have remedies? We have remedies galore. Do we have the political will to impose those remedies? That is the question. And I think that question always inevitably fails, because the answer tends to be that the state believes that it owns the resources, and the state believes that it has to trade those resources for money. So very often the people who are living in those lands are seen as not necessarily being the most important stakeholders. So their rights are often overridden. And we see this with mining licenses in Peru. We've seen this in Colin's case in Orissa. We've seen this across the world. And so it's not only in Africa, it's happening in Asia, it's happening in Latin America. You know, people who are writing in development studies call it development aggression, because that's essentially what it is, where a country decides that it's in the best national interest to allow its resources to be exploited for commercial gain. Now, there's nothing wrong with having natural resources exploited for commercial gain. Yes, they should be sustainable, key, because otherwise we are creating the kind of disaster on the climate change side that we will not be able to survive past. But in theory, there's nothing wrong with ensuring that there's a return to the investment that's coming in. The question is, who decides what that shape should be? Who decides how the fruits of it are distributed? And who decides what happens to the people who live there? So I think it's not the question, do we have adequate remedies? The answer is yes. Do we have adequate political will? The answer is no, because we still see this as a small scale, as a large scale enterprise to benefit the interests of a small number of people. I think that's where the system breaks down. And that's where you get these kinds of violations. And this is why a simple concept like free, prior, informed consent is so fundamental to everything in this space. It's fundamental to the people who are living on the land to understand that they have the right to be consulted in a full informed manner, and that they have a right to free information. It's important to the people who are looking to gain those particular contracts, the corporations, that they need to get this kind of consent. It's important for government to understand how that investment will be distributed, how it will benefit the local area, the region, and the nation, and not just a few people whose pockets might be lined, or not just some very general, oh, but it's good for the economy, we'll all be better off as a consequence of it. We need to understand where the jobs are coming from, who's getting them, how those people are going to survive in their communities, how those communities are going to be regenerated. I hope that answers some of those elements, Sarah.
I think what it was also pointing at is there's a new phenomenon, which is not just corporations, but other countries behind these corporations buying up whole tracts of land and not actually extracting anything from it at the moment. So when we know that resources are being extracted, then all these things kick in. But when we have people buying up whole tracts of land for the future and not touching it now, then I think that poses a little bit more of a dilemma around how we use the mechanisms that we do have, the legal mechanisms, the social accountability mechanisms, because as it stands, it's not clear always who's buying what, who owns what, and why. And it's a problem for the future, but it needs to be dealt with now. But of course, while they're not extracting and are not presenting any plans to extract, then when do these mechanisms kick in? I think that's one of the issues that was being raised with that, and that's one of the dilemmas at the moment about this new way of just buying land and letting the resources sit. Rather than extracting.
That's a good clarification on the point as well. But I think partly that question is very often referred to China's buying up of Africa and the One Belt, One Road. And I'm mixed on that. I'm genuinely mixed on that. I've looked at One Belt, One Road. If you see it as a development plan, it's not much different to the Marshall Plan in Europe. If you see it as an attempt by the Chinese government to spread its influence, it's not much different from American hegemony.
The West.
It's not much different from how the West treated Africa. I'm not sure it's right to hold the Chinese to a higher standard. I think
that's why I didn't mention Chinese.
I think it's right to hold China to a standard. Unfortunately, the people who are doing the holding of China to account are doing it for politically motivated reasons. As in, how dare you buy up that bit of Tanzania? It was ours from 1884 onwards, which is not quite the argument that we're really following here. So I think that the question, Sadia, is a very good one. I think there's a lot to be developed there. I think I agree with what Sarah is saying in that mechanisms possibly need to be started now. But if the land is being bought, and that ownership has transferred, what does that transfer of ownership actually mean in real terms? Does it mean people are being dispossessed? Because if they're being dispossessed, that's an issue that has to be dealt with now. So, but the dispossessions are not taking place. If it means investment is coming into a country, well, if that investment is going to achieve some of the sustainable development goals, targets, I wouldn't be complaining too much. But if what we are storing up is a long-term problem by which elite, and now maybe the elite will be Chinese and not local Tanzanians, then I'm interested immediately, because then I think it's a problem. So we just need to be very, very cautious on how we treat. We are very quick to rush in and criticize this Chinese behavior, and I think there's not a problem with that, by the way. We need, when sovereign countries operate beyond their borders, they need to be held accountable. We need to talk about it. But let's just be aware of the fact that Africa especially has been destroyed by many of these waves happening time and time again. To pick this particular wave at this particular point, let's not be, how do I put it? Let's not be taken away by that tidal wave of general critique against China just because it's not Europeans who are doing it anymore.
Thank you, Joshua. We have a follow-up question. Where is that
some of these cases as well?
Could we have insights?
Well, I couldn't agree with you more, Joshua. The tribals or the indigenous people are the poorest, and they live on the richest of the lands in terms of minerals. India is that to get at those minerals, you must necessarily, at gunpoint, push the tribals off their lands. A very powerful weapon here again. But I am amazed at how little education is done in all the education systems in India. In the 5-star or cities, law unit. It's amazing how understand constitution or academic writing rights, that is to say, from the tribal point of view, it enables them to protect their land, protect possession of their land, notwithstanding the fact that they don't have title to land. They don't have a written contract with a land for centuries of right collectively again. So there's so little. Our education system is very colonial. Our education system doesn't even teach young people, an alternative way of looking at tribal law, and it looks at it in terms of ordinary property rights, basically. So change that system where young lawyers are indoctrinated in a particular way of looking at the law will take quite some time. And I don't see that happening in the near future, unless an alternative system of develops, particularly in the developing world.
Sarah, in addition to this question, a law that was taught from a gendered perspective has understanding of the various legal frameworks that exist in our statutory provisions. Do we really need feminist jurisprudence perspective to be retaught to lawyers, or do we actually start all the way from before? We've had this discussion in other hangouts, but it would be nice to have yours and Colin's perspective on a gendered perspective of, and then practicing the law. So,
Colin, go first? Okay. So I'm sorry, you broke up a little bit, and I think the question was around: do we reteach lawyers a feminist perspective on the law, or do we completely dismantle the legal system as we've got it and reinvent it from feminist principles? As a good feminist, of course, I'd say that in the ideal world, we'd dismantle all the patriarchal structures as they exist and reinvent them. I don't live in that ideal world, so I think we have to go with what we've got, which in essence then, yes, we could put a feminist lens to the legal system to the statutes as we have them, to the constitutions as we have them, as I know Colin in essence is already doing, and go down that path. But I think there's certain structures that we do have to look at very closely, because it's this idea of using the master's tools to dismantle the master's house is always very questionable. And the extent to which we can use these systems. And as we've said, these systems, they're not just patriarchal, they're highly class-based, they're highly elitist, they come from, and I'm from the UK, and I have to hold my hand up and say, I apologize, they come from the UK in particular, and we know that class-based elitist system that operates here. And therefore, to try and think about how to change that from within is very difficult to think about. If we start from a feminist principle, of course, then at the heart, we'd say we put equality, but Joshua always argues that at the heart of human rights is dignity and equality already. So we have to look back and think, well, really, it's about what we mean by that and how we operationalize that and looking at those structures. But I think from what Colin's been saying, he's got a very interesting model there around making sure that lawyers are teamed up with social activists, and if they're feminist activists, and making sure they watch their language and how they operate. And again, if we had a feminist lens, that would bring on another layer within that. So on one level, yes, we need feminist education for lawyers in the legal system. On another level, I'm still not convinced that legal system that is built on patriarchal principles can actually bring the feminist goals that feminists desire. That was pessimistic on my part in the end.
Yeah, well, you know, Colin, Sarah is just, she strides the pessimistic side of these arguments. But to her credit, Chiteshri, this is news to you. As of yesterday, she's the acting head of the law department now. So,
oh, yes.
You know, there you go. She's trying to do it in her practical life. So,
yeah, I would add perhaps a combination of incremental change, or like a war of attrition, taking a sledgehammer to the law. There are certain areas of law which remain woman, anti-Dalit, anti-tribal, anti-slum dweller. But let's look at the anti-women area particularly. There are some areas that are entrenched in stone. Use the Constitution in whatever way you want. You can go to the Supreme Court or the High Courts and try what are clearly good arguments. And yet you could be rebuffed 1,000 times. And then at some stage, take a step and try and smash that structure altogether. Or, you know, missions of power to tell us that they have reformed and they are going to be good people now and they're going to equality for women in their communities. One experiment took place recently on the triple talaq practice, which on and on and on. And though we pointed out in numerous cases that there are Muslim triple talaq, and therefore it was not an essential part of law at all. And there was no need for India to keep that. And we tried and tried and tried, but the conservative men opinion refused to even exist of reforms. And a case was taken to the Supreme Court saying that the time has come to test anti-women aspects of personal law against the equality Constitution. And the Supreme Court was loath to do that for the last, and said that we can't touch personal law. And now the Supreme Court said, a bench of 5 judges, that yes, perhaps personal law can be tested. Clause, and if it equality clause to that extent, it unconstitutional and invalid. So now the triple, which carried on mercilessly for 5 decades, constitution, women are taking their men to court because there's a prohibition discrimination against Parsi women who marry non-Parsi men, and so on and so forth, with respect to their rights to go to the fire temple. And Christian law is coming under attack because in divorce, men have to show only one default by a woman, adultery coupled, just either adultery or cruelty, or both adultery and cruelty. So that section will now be institutional. So I can see rapid change taking place in our country, at least, where we have to demolish this structure, seemingly unbreakable structure, and take a sledgehammer and just knock it down completely and start a new law afresh to go incrementally.
So, Colin, you're with the young feminists on Smash the Patriarchy.
I'm quite an extremist, but it comes to law, kind of character.
I can testify to that. I can testify to it properly.
And on that note, I think we should start to wrap up this discussion because we do more than 5 minutes. I think we have about 5 to 7 minutes to conclude. So I'm going to invite some concluding comments from Sarah, Joshua, and then we have Colin. My sincere apologies to so many of you who've tuned in and are asking questions because our is a little bit weak, so we're mindful of that. So we just like to wrap up soon. For all those people who have more questions for Colin, please feel free to email the Human Rights Course team and we will forward them to him. Sarah, over to you. Comments for the course, for the webinars, and of course, to Colin today.
So my concluding comments is I find these conversations always very interesting. Doing the MOOC, we learned a lot when we were filming the MOOC, which seems a long time ago now. But having conversations with Joshua always, I find, and I'm sure it's come across, we challenge each other and we change our opinions as we move through, and it helps refine my thinking. And today, certainly, I found fascinating listening to Colin and hearing about these small incremental steps that can add up to bring about real change. And it makes me feel very, I know I'm a pessimistic person, but it makes me feel very optimistic when I listen to these things occurring across the globe. And in particular, to hear male feminist allies talking in this way, because I do think it's really important that men are there supporting women's claims and goals on this and can be really good feminist allies. And yes, smash the patriarchy, as Colin is basically advocating there.
Yeah, it's been a pleasure to engage in this conversation with Sarah on these Hangouts and indirectly with all of you who have been tuning in to these sessions. We hope you got something from it. I think the message that I would like to leave you with really is to just remember that in the context of the increased complexity we see, we need to understand complex solutions. We need to understand those complex solutions that build on the entirety of human potential. We need everybody pulling their weight and pulling their weight meaningfully if we are going to find really complicated paths to the kinds of problems that we face now. And if we want to create a world in 2030 that is fully inclusive, that is mindful of climate change, that understands the role that free enterprise has to play, that holds government to account, that can design complex systems, we need to start thinking about them now. We need to start actualizing them now. And we need a different set of people around policy tables and think tanks and public services than we have at the moment. At the moment, we have a very small percentage of the world's population who are involved in this area. Around 1%, I would put it. And around that, in that 1% of people who are involved, you find a great preponderance of people from the majority community and who are male. That means that we have a 1% chance of being able to configure the world's 99% problems. So we need to change that game. I hope that educational courses like this, which are not restricted to those who can pay, can ultimately spread that word further, can actually spread into that 99%. And I hope that in the personhood of people like Colin, who epitomize this struggle over decades, this is not a 5 minute, this is not a 1 year, 3 year, this is a decade long, lifetime long course for people like Colin. And I think study these people closely, understand what it is that they're saying, understand how they conduct themselves, learn from it. I certainly have. It has been an inspiration to me to see how people like Colin, who see suffering on a daily basis and see exclusion on a daily basis, can nonetheless be the kinds of humble people they are, who are keen to find solutions. You're not going to find Colin depressed and demoralized. He has far more reason than any of us can be, because he sees these sufferings on a daily basis. His lawyers get beaten up on a daily basis. I'm pretty sure he's going to have to go back to court at some point today, or a police station, from this meeting. But he doesn't let it affect his demeanor, because he understands that if you keep positive about how you can get that social change, then that's how you empower other people to follow that. Colin, when you made your speech at the Right Livelihood Award, which I was privileged enough to watch, you said that you were a diya. You said that there were many such diyas in this. Diya is a small Indian lamp. I think you have to light those diyas. You have to make sure that you light that particular wick. By itself, that diya could burn out. But if there's enough of those diyas lit, for a start, it'll become enough of an issue. And I think we live in a world now through social media where the vast majority of people can have a voice. We just need to make sure they're speaking about the right things. So I hope this course has taken you some way on that particular journey. Your involvement in issues of human rights and gender, I hope, is not just a passing fancy. I hope it's something that you will, in some shape or form, live through your values and live through your life. And I hope that we will have a chance to meet. And best wishes for it.
Now, last word to Colin.
Colin.
Those of you from Africa, South America, Asia, and so on, I just like to leave you with this idea that when you face adversity and you try to fight that oppression, very often we look at Western solutions, the UN, and it's a very important institution, I know, for Westerns. It's come now for us to look inwards and look at our own constitutions of our countries, look at the legal traditions that we have, even though they may be weak and sketchy in parts. So look at our own constitutions, look at in the pages of that constitution, to the use of constitutional law a bit more aggressively. And we have many, many precedents from all across the world to support us in our endeavor to use our constitution, constitutional courts, to take up issues that have never been taken before, to do things that have never been done before, judges with cases that have never been taken to them before, and to win that have never been articulated before our courts before, and create history in our own courts. Be a way forward.
Very powerful words there. Thank you so much, Dr. Gonsalves. Thank you so much for being with us today. And thank you to everybody who's tuned in and been a part of the course. Again, my sincere apologies for the weak broadcast signal, because sometimes we cannot always broadcast from the places which have high speed net. We're doing our best, and we hope to have many more sessions in the future. Please stay tuned with the SDG Academy. So much, Joshua and Sarah, for tuning in today. And please keep the questions coming in on the discussion forum. February 3rd to complete the final exam so that all of you can get your certificates. On that note, I'm going to say good night.
One last point, if I may. One last point.
Oh, sorry, of course.
A special thank you to you for hosting us, and special thank you for Rebecca, who, it has to be noted once again, we have not succeeded in getting in the front of the camera, but who has been extremely efficient in organizing and acting as a link between you, our viewers, and audience, and us.
And
thank you to you both.
Organising us.
And organising us,
Rebecca
of
is an
course.
organising of us, and she's marvellous, and we thank her greatly.
Okay, I lost the broadcast.
Back to you, Chiteshri. Stopped. So stop broadcast.
I think it's still there.